Hello everyone, welcome to Synthesis IAS Academy, a place where blend of ideas take place. About me, I am Sandeep Bhushan and my credentials are I have 10 years of teaching experience for civil services and I take up issue based current affairs. And my session will definitely help you to crack prelims and mains examination because throughout my session I would be emphasizing on the keywords and the key phrases, and these keywords and key phrases are certainly very important and key for you to clear prelims as well as mains examinations. So certainly you will, while you are imbibing or making sure that you are emphasizing on the keywords and the key phrases, that will help you to crack prelims and mains both for 2020 as well as 2021. So my topic will certainly help you both for prelims and mains for UPSC examination. And today's topic is labor laws and reforms in India. So we will be focusing the entire labor laws and reforms in India. And while we are focusing the main topic, that is the labor laws and reforms in India, I would also emphasize on the subtopics, because without getting into the depth of the subtopics, it doesn't really make sense in regards to making it how important the labor laws and reforms in India would be useful or will be a critical information for preliminary and mains examinations. So we'll be focusing on the three bills which have been tabled in the Lok Sabha, the three bills, and then prior to that we will also focus previous because of the three codes, or we will be focusing at the 1979 law, which is in regards to the interstate migration, and also we will get into the depth of what is the proposed code which is or which would be amending the 1979 migrant workers law. And without getting into the understanding of the colonial exploitation, that is colonial Britishers exploiting Indians, and that is how Indian laborers were exploited in different areas and what were the various acts which were during the colonial period. So we will focus those also, and after independence what are the labor rights, or just before independence and after independence what are the labor rights, and also we will focus at the dignity of labor which will or which is through the democracy in India. So we will look at a comprehensive about the labor laws and labor reforms in India. So now we will immediately focus at the three bills which were tabled in the Lok Sabha by the Labour and Employment Minister, that is Santosh Kumar Gangwar, on September 20, 2020. So he has introduced three bills to amalgamate, that is to combine all the laws, and he has introduced three codes. The first one is Industrial Relations Code 2020, and the second one is the Occupational Safety, Health and Working Condition Code 2020, and the third one is the Code on Social Security. So which is that you need to focus here is that key words or the key codes, which are the one is the first one, the Industrial Relations Code 2020, Occupational Safety, Health and Working Conditions Code 2020, and the Code on Social Security 2020. So there are actually four codes which have been amalgamated, which have been conjoined, which have been joined together, and then entire 29 labor laws were part, or definitely they are part of the four codes which have been amalgamated. And now we have seen that on September 20, 2020, three codes were passed or introduced, and the fourth code was or is the code on wages, which was passed in 2019. So please do understand, in 2019 one code was passed in the house, that is the code on wages, and now in September 2020 three codes have been introduced. This is the analytical point of view which you need to focus. So entire four codes have been amalgamated, and now the government is definitely getting ahead with these three bills now introduced, and the earlier bill which was the code on wages, that is the entire all four codes or four bills they have been introduced because the government is very particular about labor law reforms, and this is the key word, labor law reforms agenda in India by the government of India. And now we will focus at this Industrial Relations Code 2020. So if you focus this Industrial Relations Code 2020 or the bill, it mandates that a company which has 300 or more workers, so definitely they have to prepare and submit to the government a standing order, which is in regards to the orders are in regards to the, they have to submit it in regards to the conditions of the services and the shift systems and the termination of employment. All these have to be mandated by a company which is having around 300 or more than 300 workers, that is pertaining to Industrial Relations Code Bill 2020. And the earlier, if you had that, it was only up to 100 employees, and that was the establishment was up to 100 employment employees, it which was under the Industrial Employment Standing Orders Act 1946. So now we have been amending the earlier Industrial Employment Standing Orders Act 1946 with the Industrial Relations Code Bill 2020, wherein now the companies with around 300 or more have to prepare and submit the condition of services of the employees. But earlier it was only 100 employees. So the difference is this. And the second one is that the Social Security Code Bill, and this bill proposes to bring in all the unorganized sectors and then gig workers. Gig means the one who are for temporary period, and the platform workers. So all the unorganized workers, the gig workers and the platform workers, they should be or they will be under the ambit of social security scheme which the government is providing by the Social Security Code Bill 2020. So they will fall or they will come under the ambit of social security scheme. So when we are talking about the social security scheme for the unorganized sector, gig workers and the platform workers, it will be including the life insurance, disabled insurance, health insurance, maternity benefits, provident fund, and all the skill upgradations which are required for the employees in the unorganized sectors and for the gig workers and the platform workers. So the third one is the Occupational Safety Code Bill or Safety Code 2020, and this is proposing to subsume in the sense to bring all into one, or to get subsume is to get into one. So subsume the Interstate Migrant Workmen Regulation and Employment Condition of Services Act 1979. So it's generally called as Act 1979. So this Act 1979 is related to interstate migrant workmen, and this was the one which was a lot in the news during the COVID-19 or in the month of April, May and June also, because of the migrant workers which they were shifting from the cities to the villages. But actually it is the workers who shift or migrate from the villages to the cities. But it was in the month of March, April and May we have seen the migrant workers or the migrant workers crisis because of the COVID-19 pandemic situation. The health crisis has erupted, economic crisis has erupted, and then the labor crisis has erupted. So this crisis, that is the migrant workers or the labor crisis, has been highlighted, and that is very particular about one act, that is in regards to the migrant workers. It is the 1979 Interstate Workmen, and now all the or the previous 1979 Act will now be subsumed into the Occupational Safety Code 2020. And the fourth one is the Wages Code, which has been already passed in the year 2019. So now we will look at what does the exact 1979 law in regards to the interstate migrants talks about, or it actually tries to make sure that it protects the interstate migrant workers. So this act it regulates the employment. It tries to have a control over the employment of interstate migrants and their conditions of service. So this is in regards to their employment and their conditions of service, and it is applicable to every establishment. That means the 1979 law for the interstate migrants, it is applicable to every establishment or an company or an organization which has an employees of five or more migrant workers from various other states getting into one particular state, or from one state to another state, and they can be above 5 or more than that, and on any given day in the entire 1 year. So definitely there has to be, I mean this 1979 law will be applicable to the establishment, that is company or organizations which employs less than or more than, or it is 5 or more than migrant workers, and it also envisages a system of registration. This is the keyword. So definitely in the 1979 interstate migrants law, it very clearly talks about the registration. So here registration of what? Registration of the establishments, that is the company or in regards to the organizations wherein they employ the workmen or the interstate migrant workers wherein they employ. So this is that they envisages a system of registration, that each and every establishment should be registered one, or else they are prohibited from employing the interstate workmen. Here if they are not registered, then they cannot employ the employees from the interstate workmen, and definitely they have to have a certificate of registration. That means they have to register, there has to have a certificate of registration, and they should also obtain a license. They should also obtain a license wherein a particular organization or establishment will employ the employees from interstate workmen through a contractor, and this contractor should definitely have a license. So you should have a license to the contractors, and you should have a registration to the establishment. So this is the one which really protected the benefits or the labor laws in regards to the interstate migrants through the 1979 law. So the main important is establishments should be registered, and the contractors should have or should have obtained license, so that they can recruit the workmen and further provide it to the establishments which would be employing interstate workmen. And now we will focus on the proposed code of migrant workers. So definitely, as we said, that the 1976 Interstate Migrant Worker Act, 1979 Act will be subsumed. So now we will look at how it will be subsumed and what are the other acts which will be now subsumed. So definitely there are attempts to consolidate laws. So it is, they are trying to bring various laws or various acts into one. So definitely there is a proposal to repeal 13 acts, and they wanted to consolidate, get it or make it into one law. And you have the proposal that the law to repeal the earlier 13 acts, for example, Factories Act, Mines Act, Dock Workers Act, Interstate Migrant Workmen Act, when we are talking about 1979, and various other enactments or the acts, so that the one who are working in the plantation or in regards to the construction field, cinema, BD and cigarette manufacture or motor transport, and in the media also. So everyone, all the employees who are in the various establishment, they would be brought under one law. There would be consolidation of all the 13 acts into one law, and that is a proposal. And the code contains almost the one, which one are we talking about? Definitely it is in regards to the occupational safety code. This is the one. So all that 13 or 14 will be subsumed or consolidated into one act, that is occupational safety code of the employees, that is interstate migrant, all everyone will be brought under one. And this code has almost similar to 1979 act, which is we did discuss about the registration of the establishment and the license to the contractors, and definitely it will have the terms and condition of the number of hours the workers have to work, and what is the wages or the salaries and other amenities wherein the establishment or the contractor will provide to the workers or the laborers. And regarding the interstate migrant workers, the act includes them as the contract laborers. Look at it. It it is in regards to the interstate migrant workers, that is Act 1979. It considers the interstate migrant workers as they put it or they define it under contract labor. And the old act and the proposed code, that is the Occupational and the Safety Code 2020 and the Interstate Migrant Workers Act 1979, both the acts envisages the payment of displacement allowances. So the allowances would be provided to the workmen who are being transferred or who have been brought in from one state to another state. So what allowances would be provided in the both the earlier, that is Interstate Migrant Workers Act 1979 and Occupational and Safety Code 2020 is you will have the displacement allowances and also the journey allowances to interstate migrant workers. So here the two keywords are the displacement allowance and the journey allowance are the two keywords. So these are the one which the Occupational Safety Code and linking it with the earlier one, that is the Interstate Migrant Workers Act 1979. So by this you will have the entire understanding about the previous act, which is very important and which was largely spoken during the migrant crisis in the month of March, April and May, June also. So definitely 1979 has to be linked with the Occupational and Safety Code 2020, wherein you will definitely have a very good question also which can be framed based on the 1979 Interstate Migrant Workers Act. And without having a knowledge or without having an information about the acts which were actually being part of the colonial or British India or colonial period, and that was those acts were exploiting Indians in the labor force, and we will definitely focus that, which will be very useful for you, because we are looking at this labor laws and labor reforms comprehensively. We are not just talking about what has been the bills which have been introduced in the Lok Sabha in the year 2019 and then again 2020. No, we are trying to focus back to 1971, and we are not stopping at 1971. We will certainly go back to the colonial period, that is way back to 1819. So definitely if you look at the British Indian time or colonial period, it was a barbaric system of indentured labor. It was a barbaric system of indentured labor. Indentured means it is a bonded labor, and that was introduced on Indians in British India through a regulation called as Bengal Regulation 7 1819. This is very crucial and critical information which I am providing through my lecture to you all, that is to all the civil servant aspirants, wherein you will have a broader understanding about the labor laws right from 1979 or independent India and then during the British India time. So Bengal Regulation 7 1819 was the regulation which was used or which was introduced on the British planters in Assam tea estates in northeastern states. And by this Bengal Regulation 7 18 19, the workers had to work compulsorily through a contract for 5 years, and if they are trying to desert in the sense if they are trying to move out when they did not like to work in the Assam tea estates in the British planters, So they were being punishable. They were being punishable. And not only that, they didn't stop at the Bengal Regulation 7/1819. They have come up with a new act that is called as the Transport of Native Laborers Act 1863. So 1819, and now we are focusing at 1863. So this act is called as Transport of Native Laborers Act 1863, which was passed in Bengal. Why they have passed in Bengal? Because it has strengthened that the tea estates or the British planters will have the total control on the employees, that is the Indian laborers, Indian working in the Assam tea estates, which were part of a system called as a barbaric system of indentured labor. And this, the Britishers had the control on the employers, and they also can, now with this act, they can detain the laborers who are trying to move out of the contract. Instead, they can also imprison them for 6 months. So earlier it was only punishable. Now they can imprison for 6 months. So now again we'll focus on the third one, that is a new act, that is Bengal Act 6 of 1865. So 1819, 1863, 1865. So 1865 is Bengal Act 6 of 1865, and this was passed, or it has come into existence, and this the British planters have brought in, or they have passed in, because they can deploy special immigration police. Look at it now, because when the Indians did not want or did not wish to work in the Assam tea estates under the British planters, they were moving out. That means they were deserting the places, that is Assam tea estates, and by the Transport of Native Laborers Act, they were detained, they were brought to the district of employment, they were imprisoned for 6 months. After that, they have come up with the Bengal Act, wherein there they can deploy special immigration police. Why? To prevent the laborers from deserting or leaving and return them to the plantation after detention. So there was an vigilance put forth by the police, not the British planters. Look at it. It started by the British planters trying to force them to work in the Assam tea estates, get them back if they are leaving, deserting, and then detain them, punish them, detain them, imprison them for 6 months. Later on, by the Bengal Act 6 of 1865, they started deploying special immigration police, and this police will now prevent the laborers from leaving, and they will bring them back to the plantation to work. And that is why I said it is a barbaric system of indentured labor. It is a bonded labor. And definitely the labor laws in India emerged because of this three. If you look at Bengal Regulation 7/1819, Transport of Native Laborers Act 1863, Bengal Act 6 of 1865 has really put forth a lot of trouble onto the Indians who were working as a laborers in the Assam tea estates or under the British planters. And this, the labor laws in India emerged today, what we have has emerged out of the workers' struggle. What we were talking about, the barbaric system of indentured labor. That is a struggle wherein Indians have actually experienced, and this has really been much of the freedom movement also against the oppressive colonial industrialists. So definitely the oppression which the Indians have experienced in the colonial industrialist has been part of the freedom movement. So look at it, we are able to link the labor struggle to the freedom struggle or the freedom movement. So this is how you need to get into the mode of linking one topic to the another topic. So it is the labor struggle, we are linking it with the freedom movement. And since 1970s, they started with a series, that is opposing the colonial industrialists in regards to the workers' struggle, that is the barbaric system of indentured labor. They have come up with the various strikes and agitation in regards to the working condition, and in turn gradually a trade unionist have definitely formed, and there were strikes, there were agitations, and then later on all these people who were involved in the strikes and agitation were arrested under defense of Indian rules. This is again the keyword. They were arrested, that is the workers or the trade unionists were arrested under the defense of India rules. And then Britain was forced to appoint a commission called as Royal Commission on Labour, so that the working condition would be as per the employees or the Indians who were working under the colonial industrialist, and they have, which this commission has submitted a report in the year 1935, that is the Royal Commission on Labour has submitted a report in the year 1935, and thereby the Government of India Act 1935 enabled a greater representation of Indians in lawmaking. Because of the Royal Commission on Labour in 1935, again we have this Government of India Act 1935, wherein in the Government of India Act you have the greater representation of Indians in the lawmaking of the Government of India Act 1935. And all these reforms were the forerunners to the present labor enactment. So we know that the three bills were definitely been introduced in the Lok Sabha on September 20, 2020. But we need to get to the background of it. So colonial exploitation, we have looked at the three acts, and then also the Defense India rules, and then the Royal Commission on Labour, which has submitted its report in 1935. And because of all these reforms, all these struggles, there was reform to the labor what we have today, and the indentured plantation labor saw a relief in the formation of Plantation Labor 51, extremely sorry, Plantations Labor Act 1951, that is post India's independence. Look at it. So here slowly we have, before this we have the Factories Act 1948, Wages Income Act 1948, later on the Plantations Labor Act 1951, which talks about or which focuses on the working condition of the Indians working in the colonial industrialists. And now we will focus at the labor rights, because once we have been independent, we have been sovereign and republic, so definitely we need to protect our Indians. Not only we were worried about the Indians under the British rule, but Indians under independent India also. So thereby Dr. B.R. Ambedkar has definitely advocated for the rights of the labor. So he was the one who was a messiah and advocated for the rights of the labor, and he was instrumental in passing the working condition of 8 hours, which was earlier 14 hours. So he has brought in that 14 hours and squeezed it and further brought into 8 hours, wherein he wanted to make sure that the rights of laborers are protected. And we have seen that labor movements, which were also been a key to the successful for the freedom struggle, because I said that the struggle, or else the laborers who have struggled have been part of the freedom struggle, I said. And definitely the 1931 Karachi Declaration and the Bill of Rights were definitely a forerunner of the Indian constitutions, and definitely they have placed the labor rights on par with ordinary civil rights. This is the keyword: labor rights and then the ordinary civil rights, such as freedom of speech and expression. So definitely Dr. B.R. Ambedkar has been advocating, and he was instrumental in making sure that the working conditions, the wages and the amenities which will be provided to the laborers, not only during the British India but also in the independent India. And definitely in the preamble, in its preamble, it is very clearly declared that political freedom It is not just we were worried about or we are happy with the political freedom. That is, India is independent, sovereign, and republic. No. Political freedom must include real economic freedom of millions, that is the rights of the labor. And these principles eventually found their way in the Indian constitution, that is in the DPSP, that is directive principles of state policy, and few of them are also retained in the fundamental rights. And this is the one which is the article which talks about right against the forced labor is article 23, which is enshrined in the Indian constitution. So definitely the labor rights are focused, and it is, we need to look into it, because the number of hours which were earlier 14 hours has been squeezed or reduced to 8 hours, right? And that is the main or the focus of the labor rights. And then further it was included as an in the DPSP and the fundamental rights, and also in the article 23 of the Indian constitution. And now we will also focus at the dignity of labor. So when we are talking about labor or labor laws or labor reforms, what is very important is the dignity of labor. So we need to have the dignity of labor through democracy. So definitely the democratic legislative process, that is the parliament, has stepped in to protect the labor. So which were the labor acts post independent or post India's independence, which have been providing or which has provided dignity of labor to the labor through democracy, that is the Factories Act 1948. So which has brought in 8-hour work shift with overtime. If there is any overtime, then the overtime wages would be paid, and you will have a weekly off, and you will also have, that means part of the Factories Act 1948 will have a leave with wages. And there were various measures even for the health and hygiene and safety of the workers also. And you have one section of Factories Act, that is section 5 of the Factories Act. Here the section 5 of the Factories Act gives more powers to the state government, that is it empowers the state government. Why? It is in a very exclusive condition, that is at the time of the public emergency or whenever there is grave emergency, which is for the security of India or any part of the territory of India. Therefore, or else it could be a kind of situation, a war or an external aggression or internal disturbance is bound to take place. So in that situation, war or external aggression or internal disturbances or grave emergency or public emergency, in that cases the Factories Act 1948 would be under the control of the state governments, and that is mentioned in the section 5 of the Factories Act. And now we will look at the second one, wherein the parliament has provided or it has stepped in to protect the labor by providing the dignity of labor, is the Industrial Labor Dispute Act. So if there are any disputes or any kind of issues between the workers and the management, it should be resolved. There has to be a negotiation, but it should not be in a such situation wherein the factories or the industries would be under a strike or an agitation or the entire lockout of the factories. No, that should not be. But it provides, that is the Industrial Dispute Act provides the workers' participation. If there are any issues in regards to wages or any other disputes, that has to be resolved through negotiations. But there should not be any kind of strikes or lockouts, because that will impact the economy of the nation itself, independent India itself, and it will also impact the labor also. And now we will focus at the another important section of the Industrial Dispute Act 1948, that is the section 36B, which is part of the Industrial Dispute Act, that it has few exemptions for the government industries, so that if there is an investigation going on or there is a settlement going on in those disputes, wherein an investigation is going on earlier existing and a settlement. So thereby this section 36B, it exempts the government industries which are into the investigation and settlement. So section 36B is crucial again. And the other one act is, which has provided the dignity of labor through the parliament, is the Minimum Wages Act 1948. And by this, it ensures minimum wages for the employees, and that is further in the directive principles of state policies, and it will protect the right to life and right against exploitation against Article 21 and Article 23. So for preliminary perspective, UPSC point of view, Article 21 and 23, which talks about protecting the right of life and right against exploitation, is Article 21, and Article 23, which is enshrined in the Indian constitutions. And definitely you have the trade unions who plays a critical role in transforming the life of the worker that were in the servitude, that is, as they were in the indentured labor during the British colonial period, and now it will be providing a dignity to the labor, and that will definitely create socio-economic justice in this society. And the another dignity of labor which has been again, which can be experienced, is in a Supreme Court verdict, which the case was between Life Insurance Corporation versus DJ Bahadur and others in the year 1980. The Supreme Court has highlighted, or it has come up with a judgment saying that any changes in the condition of services to the workers, it should happen only through a democratic process or in negotiations or legislations, but it should not be any kind of force which should be imposed onto the laborers, and then they would be squeezing or suppressing the labor rights. So any changes in the condition of the services or any changes in regards to the legal provisions of the labor rights should be, or it should be only through a process, that is democratic process of negotiation and legislation. So I hope this entire session was an informative and a knowledgeable one to you all, that is to all the civil servant aspirants, and certainly my session will provide you an edge over others in prelims as well as mains examinations. So I would say a big thank you to all and a good luck to you all. And before you sign off, do like the video, share the video, and subscribe my YouTube channel, that is Synthesis IAS Academy, a place where blend of ideas take place. And see you again with a new topic which will be certainly useful, informative, knowledgeable for UPSC perspective point of view. Thank you very much.